Hello everyone, now we're going to study the content of Chapter 1, Section 3, Overview of the Work Process, Basic Business Procedures of Import Trade. 2. Basic Business Procedures for Import Trade. 1. Transaction Preparation. The preparation for import trade transactions includes investigation and research, import cost accounting, and import license approval. 1. Investigation and research. In order to ensure the quality and quantity of imported goods, importers before trading need to conduct investigations into domestic and international markets, including the goods production, supply, sales, and customer situation, especially to understand the major producing countries and major producers, supply situation, the market situation of the goods, and the credit situation of suppliers. 2. Import cost accounting. Importers of goods, whether for domestic sales, personal use, or processing, must account for import costs in order to minimize import costs, save foreign exchange expenses or retain a certain amount of foreign exchange, increase actual import volume, thereby improving the economic efficiency of the enterprises. For the import of bulk goods, it's not only necessary to calculate the import cost, but also to formulate a detailed import pricing plan, including pricing principles, pricing methods, price accounting, and price adjustment measures. 3. Import license approval. In order to standardize the management of imported goods and maintain the order of imported goods, the country manages 3 types of imported goods, including restricted imported goods, freely imported goods, and prohibited imported goods. Restricted imported goods are divided into licensed goods and tariff quota managed goods. Free import goods refer to the country aims to conduct statistics, and the need for supervision require enterprises to import before goods subject to free registration. Goods that are prohibited from importation are not allowed to be imported by any enterprise. For other types of imported goods, importers should, accordance with regulations, handle the import license approval procedures with the competent authorities in. 2. Contract agreement. Similar to export transactions, after importers, during the preparation stage of the transaction, completing investigation and research, import cost accounting, and import license approval, can, based on research results, select trading partners, conduct business negotiations, and strive to sign import contracts. The contract negotiation process of import trade also includes negotiation preparation, contract negotiation, and contract signing, 3 work contents. Each stage is basically the same as the export contract. 3. Contract performance. 1. Apply to open a letter of credit. If the import and export parties agree in the contract to settle the payments by letter of credit, the importer, applicant for opening the letter of credit, shall strictly follow the time and the requirements stipulated in the contract. To the bank in its location, issuing bank submits the request for opening the letter of credit according to the content of the trade contract and fill out the letter of credit application form, together with the required attachments such as the sales contract, etc., and submit it to the issuing bank. After the issuance of the letter of credit, if it's found that the content does not match the application for opening the letter of credit, or if there are other reasons, such as changes in the situation, that require modification of the letter of credit, the procedures for modifying the letter of credit should be immediately applied to the issuing bank. 2. Chartering and booking. In import business, such as EXW, FOB, FCA, FAS, etc., contracts concluded using trade terms shall be arranged for transportation by the importer, and a transportation contract shall be concluded. In China, importers generally entrust international freight forwarding companies or shipping companies to handle the consignment procedures for goods. After the contract is signed, the exporting party shall notify before delivery within a certain period of time the expected readiness time, gross freight, volume, and other detailed information. The importer should be notified upon receiving the information of the goods, timely handle the chartering of goods or booking procedures, and after completing the procedures, according to the deadline stipulated in the contract, name the ship, shipping schedule, and other matters. Notify all exporters so that it can prepare goods for shipment. 3. Insurance coverage. In addition to using CIF, CIP, and D group trade terms, outside of the executed contract usually imported by the importing party, apply for insurance for importers or consignees. Purchasing insurance. There are two methods to choose. One is to book insurance, that is, the importer with the insurance company signs a pre-arranged insurance contract for imported goods that fall within the scope of the pre-arranged policy. Once loaded onto the ship, the insurance company is automatically responsible for underwriting. Secondly, purchase insurance on a case-by-case basis. After receiving the shipping notice from the foreign party, the consignee directly goes to the insurance company to handle the insurance procedures, and the insurance company accepts the insurance and issues a formal policy. The importer should promptly handle the insurance procedures for imported goods, whether through appointment insurance or individual insurance coverage. Otherwise, before insurance is purchased, during transportation, if the goods are lost, the insurance company shall not be liable for compensation. 4. Payment through document review. Reviewing the documents of imported goods is an important step in fulfilling the import contract. The goods document is the basis for payment by the importer and is also the proof for verifying whether the imported goods match the contract or letter of credit. In import business, if collection and remittance methods are used, the importer is responsible for conducting a comprehensive review of the goods documents. If a letter of credit is used, the issuing bank and the importing party shall jointly review the documents, confirm that they are correct. After confirming that the documents meet the conditions stipulated in the letter of credit, and make payment. 5. Inspection report. After the legally inspected imported goods arrive, the consignee must register with the inspection agency at the port of discharge or arrival station. At the designated inspection location and within the specified time limit, present the contract, invoice, packing list, bill of lading, and other documents to the inspection agency for inspection. Imported goods that are not subject to statutory inspection and are stipulated in the foreign trade contract to be inspected by the inspection agency must also be reported for inspection. Imported goods that have not been inspected are not allowed to be sold or used. For imported goods other than those subject to statutory inspection, if the foreign trade contract does not stipulate that they shall be inspected by the inspection agency, the consignee shall, in accordance with the contract provisions, conduct acceptance inspection. The inspection agency may supervise the consignee to inspect and conduct spot checks. If the acceptance is not qualified, and claims need to be made with the inspection certificate, of the Commercial Inspection Agency. The consignee should promptly apply for inspection and certification from the local Commercial Inspection Agency. 6. Customs declaration and delivery. The consignee of imported goods should declare from the transportation vehicle within 14 days from the date of entry at the customs of the place of entry of the goods. Handle the import declaration procedures. Import customs declaration generally includes import declaration, inspection of goods, valuation and taxation, and release with signature 4 main steps. After the goods are inspected and released by the customs, the consignee can present it with bill of lading stamped with release seal. Go to the customs supervised warehouse or pick up the goods at the designated location. 7. Import claims. In import business, sometimes there may be situations where the seller fails to perform or fully performs the obligations stipulated in the contract, such as not delivering or delivering goods that do not fully comply with the quality, quantity, packaging, or delivery time stipulated in the contract, causing the buyer to suffer losses and file a claim. If the quality, quantity, and packaging of the goods during loading, unloading process are damaged, or if due to natural disasters, accidents, or other external reasons causing damage to the goods, the importer shall file a claim with the relevant responsible party.